The Kadhis court is an important institution for Muslims in Kenya. It provides them with a forum to have their disputes resolved according to Islamic law. The Kadhis courts are established under the Article 170 of the Constitution. Their jurisdiction is limited to the determination of questions of Muslim law relating to personal status, marriage, divorce, or inheritance in proceedings in which all parties profess the Muslim religion and submit to the jurisdiction of the Kadhis court. So what happens when a dispute is between a family of Muslims and non-Muslims? I sat down with the Deputy Chief Kadhis, Sheikh Sukyan Hassan, who takes us through the Kadhis court jurisdiction.
Kadhis court, like any other court, is a creature of a law. Specifically, is a creature of the supreme law, which is the Constitution, and as well as the Kadhis Court Act. And this law outlines the area of the operations, the scope of the operations of each and every court. But for us, the area of our jurisdictions are very much limited and well defined. It begins with the issue of the marriages, generally whatever marriage it is, in general. There are a lot of issues on the marriages. Divorce is all, a lot of things around there. And issue of inheritance, and as well as personal status, which is not very much defined. Perhaps I can say that the marriage, the divorce, and as well as the inheritance still fall under the personal status. We are dealing with Muslims. Our area, even within that areas that given to us, the court normally serves clients who are purely Muslims, because the law is very clear that in those areas, question of Islamic law, in those areas, question of Islamic law, where the parties that want that service are all Muslims. Apart from that, the Constitution, the new Constitution especially goes further. It says even those ones must submit to the jurisdiction of the court. So that's the area that we operate. Therefore, from that, our clients we expect what to be entirely Muslims. But when it comes to, it doesn't mean that Muslim cannot marry a non-Muslim. Sharia is very clear. For example, the question is, if somebody disputes a Muslim man married to a Christian woman, whose marriage, for a Muslim man to marry a non-Muslim woman who's a Kitabiya means people of the book. In our case, the Christians are the majority here. If the dispute comes, where can it be litigated? Remember, the wife is not a Muslim. The husband is a Muslim. How do you handle such things? So the law literally read both the Constitution and the Kadhis Court Act that our court is not the right forum. Maybe they are at liberty to go to other court to litigate. But the question is, what about if both of them submit to the court and say, look, we were satisfied to be litigated here? Still, there's an issue. Still, there is an issue. And likewise is the inheritance. Inheritance is the same. All the parties who are beneficiaries, all parties that involved must be Muslims. This notwithstanding that the law is very clear. The Law of Succession Act, Cap 160, is very clear that the estate of a deceased Muslim is distributed in accordance with the Muslim law, with Islamic law, Sharia. So the focus is the deceased, not the beneficiaries. All right? So it makes no difference then from that point of view that whether you come to the Kadhis court or to other courts, provided the deceased is a Muslim, the owner of the property is a Muslim, the inheritance rule that governs will be the Islamic law of inheritance. Right? So it makes no difference whether you are at Supreme Court, Court of Appeal, High Court, Magistrate Courts. It makes no difference. So that's where we are. What happens is that any case that we do, okay, is appealable to the Superior Court. So any party who's not satisfied, all right, have the right to appeal to the superior court, which is the high court. So we are always under the supervision of the superior court, which is the high court. In fact, every court station, every lower court, okay, is under a certain high